Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So, with the Karen Reid trial ongoing, some of you have asked me, can we cover something else as well? Just a little bit of a break, maybe something lighthearted. So, we're going to cover a case about dongs. This is the case of Bad Dragon Enterprises against SinSaint. Now, I covered this a bit on some of my lives, but this is a refiling because earlier Bad Dragon sued SinSaint and they had the case punted on jurisdictional issues. So they've refiled it in SinSaint's home turf, and now the case is ongoing. Now, this case is 20 pages. We're going to go through it, but thankfully, a lot of it is going to be repetitive, so we can sort of skip over a fair bit. Now, this case is going to take a while to cover as well, because cases just, they don't really move fast. So this is going to be a long and hard process for Bad Dragon. And I hope that they're able to stand up straight and keep going to a glorious finish. All right, so here we go. You might also want to pour yourself a little drink because this is a fun case. And, you know, here we go. Plaintiff, Bad Dragon Enterprises, brings this complaint against defendant SinSaint Incorporated. Preliminary statement. Plaintiff is an industry-leading developer, manufacturer, and seller of adult entertainment products, including its extensive line of fantasy-themed sex toys. Now, if you're not familiar with the Bad Dragon Company, when they say fantasy-themed sex toys, what they mean is, well, how do I put this in a way that doesn't get this channel nuked from orbit? They make artificial genitals for that are at times resembling fantasy creatures, at times more resembling animal parts or something else. Anyway, they are kind of a fixture on the internet. So they have become famous for making things that nobody expected. And I assume they've made a whole pile of money along the way, which might surprise a whole lot of people. Cheers, I guess. All right, so Plaintiff has obtained numerous copyright registrations for the unique original. Unique and original is a fair way to put it. Sculptural design elements embodied in many of its sex toy products, including those at issue in this action. Now, they did file an exhibit that actually shows a lot of the images. And I'm not going to show them because I would probably get demonetized or a strike or something. But they are out there. So, in January of 2024, Plaintiff discovered the defendant directly copied at least 13 of Plaintiff's copyrighted products and sold substantially similar products that are copied from and derivative of those copyrighted products, even going so far as to market, display, offer, and sell them at the January 2024 AVN Awards, the premier adult industry sales convention and awards show sponsored and presented by the trade magazine Adult Video News. Now, I'm pretty sure Bad Dragon would have been at that convention. And so this is, not only would this be, the allegation is stealing their copyrighted works, but also kind of rubbing their nose in it in a way they don't like. Now, you might be wondering, wait a minute, you can copyright a design for a artificial dong? And the answer to that is yes, because they do involve some level of artistic element that goes beyond just their pure functional elements. They're going to get to that, but they do actually hold copyright registrations, and the copyright for this is almost assuredly valid. I say almost assuredly because there's always some weird possibility, but yeah, there really doesn't seem to be any issue with the copyrights. Okay. Parties, jurisdiction, and venue. Plaintiff is a Nevada corporation with its principal place of business in Arizona. And They originally tried to sue in Arizona and got punted for lack of jurisdiction. Bad Dragon's lawyers and Bad Dragon themselves made a mistake here, which was they really ought to have bought the infringing artificial dongs before they brought the suit. Because at the end of the day, their first lawsuit gets thrown out because they couldn't ever prove that SinSaint had sold one of the infringing dongs into Arizona. So if Bad Dragon had purchased some of those beforehand, then they would have been okay, but they didn't. So, oops. But regardless, it's not fatal. It just means that they have to file again in New York, which is what they've done, and that's the case we're looking over here. Defendant is a New York corporation with its principal place of business in Brooklyn, New York. So this, you can see why it's more convenient for the defendant to defend in New York. Court has subject matter jurisdiction. Court can exercise personal jurisdiction because the defendant is headquartered within and has its regular place of business within the district. Cool. So, general allegations. This is what Bad Dragon says SinSaint did. Plaintiff and its copyrighted works. Plaintiff is a well-known adult toy company. And I would say that they are a well-known adult toy company. I am not a customer of Bad Dragons, but I've become aware of them because they're kind of an internet meme. People talk about them. People joke about them. And I'm sure that some of the people out there are buying these things because this company has been in business for a long time and continues to exist. So they must be doing something right or weird. So that has won numerous adult industry awards for its innovative, fantasy-themed adult products and design. Innovative is a fair way to describe it. Among Plaintiff's many innovative and unique products are the following. Unique is also a way to describe it. Crackers the Cockatrice. And they have links, which I'm very much not going to click on. Fenrir the Wolf Dragon. Kelvin the Ice Dragon. Pretzel. I don't want to know. Razor the Doberman. You can use your own imagination here. I refuse to imagine this for you, and yeah. Stan the T-Rex. Again, no, I'm not showing you, and no, I refuse. Spritz the Sea Dragon, Ika, and Nocturne the Enderfang, Virgil the, and my apologies here, Drippy Dragon. That's a whole sentence. Marcel, Echo's Horn, and Tyson the Water Buffalo, which is trademarked. So is Virgil the Drippy Dragon and a few other things. Okay. Looks like just about everything's trademarked, so they've got a busy IP lawyer who has some of the, who has one of the more interesting jobs on the planet. No, interesting, not necessarily good. Each of the 13 products listed above, collectively, the copyrighted works, although I suspect Bad Dragon probably pays well and on time, so feature unique, original sculptural design elements that are separable from the underlying useful article and are protected under U.S. copyright law as sculptural works pursuant to the law. Now, why is this important that there are unique original designs? Well, copyright doesn't protect things that, aren't to some extent unique in the exercise of sort of human creativity, and also the separable from the underlying useful article. Copyright doesn't protect useful elements. So what that means is that to the extent that you need a design feature in order for something to function, you can't copyright it. I'll just pick an example here. Screwdriver. The screwdriver works because it's got this, end that engages with the screw and allows you to turn it. Shit, I didn't even mean that, but here we are talking about screws in... Nope, moving hastily. So, you can't copyright the end of the particular... damn it. The end of the particular tool that this is going to be a landmine of of things I want to avoid saying, but oh well. Um, because that is the useful article. If you want to protect a useful article, that's got to be a patent, and patents are much more limited in a variety of ways than copyrights are. So, Plaintiff owns valid and enforceable copyrights in and to each of the copyrighted works. And they have exhibits with the copyright registrations. The copyright registrations actually look fairly boring. They just sort of list the name of the thing and they say we registered it. So, yeah. Plaintiff has enjoyed significant commercial success selling products that embody the copyrighted works to wholesale and retail purchasers in the United States and in other countries, and has sold significant quantities of those products to those customers over time. So basically, they're like, we are doing great. We're selling these things like hotcakes, and it's no wonder why somebody would want to copy our specific dong designs. They want our money, our dong money. Plaintiff has reserved all legal rights in and to the copyrighted works and has not authorized anyone to reproduce, distribute, make derivative works of, display, or to make any other unauthorized uses of them, or any portions thereof. They do not allow unauthorized uses for their novelty dongs. Okay. Yeah, moving on. I'm going to be giggly during this, and it just is what it is. Defendant's willful infringement of the copyrighted works. Defendant has advertised, marketed, displayed, reproduced, displayed. Oh, they've got displayed in there twice. I guess they displayed it more than once. Offered for sale, sold, and distributed certain sex toy products through its website, SinSaint.com, and through certain other trade channels, including at the January 2024 AVN Awards. Again, I'm not following any links here. If there's a link, it's remaining unclicked. Among defendants' previously sold products are Asmodeus, previously found at, because all of these URLs were taken down when Bad Dragon basically started saying, we might sue you over this stuff. They took a bunch of this stuff down, which, sensible. So, the Asmodeus, which they're saying infringes Crackers the Cockatrice. Astaroth, which they're saying infringes Fenrir. You'll notice there's some demon and so forth themes here. Behemoth, which they say infringes Kelvin. Cobra infringes Pretzel. Crane infringes Razor. We're just going to go with the names. Gar, Idol, Lao, Monarch, Ogle, Sauron, Tomi, and perhaps the least surprising name in this whole list, Willie. Willie kind of doesn't seem to fit here because of all the other, So each of the 13 products listed above, collectively the infringing products directly copied, is substantially similar to, and therefore infringes, the corresponding copyrighted work listed above next to defendant's corresponding product. A chart depicting each of the copyrighted works and each of the infringing products is attached here too as Exhibit N. I have reviewed Exhibit N. Exhibit N will not appear in this video because I would probably get in trouble. But it shows a variety of unique fantasy items, and then another not so unique fantasy item that looks just like the one that Bad Dragon makes. So yeah, there are some slight differences, but they're pretty close. Okay. Because each of the infringing products directly copied the protected sculptural design elements in the corresponding copyrighted work, defendant is liable for direct infringement in each of the 13 copyrighted works. On information and belief, defendant's infringement is willful, as indicated by its copying of 13 separate copyrighted products from one source, that is, Plaintiff. Now, I'm not a big fan of on information and belief for the views of other people, because you can't really information and belief psychic powers. But they do actually give a good basis for drawing this conclusion. They're like, we think it's willful because they copied 13 things. It's not that this was an accident. It's they pretty much had to be browsing our stuff and maybe use... I don't know if they ordered like sample copies for product testing. And I'm going to drink to forget that idea. Okay. On January 31st, 2024, Plaintiff's counsel sent defendant a demand letter. The demand letter. Therein advising defendant of plaintiff's ownership of the copyrighted works and defendant's copyrighted infringement of the same through the infringing products. So, this would be perhaps a cease and desist, but also some other things. Now, what is a demand letter? A demand letter is basically a legal do this or else. And a demand letter or a cease and desist or whatever else basically says you are infringing our whatever, and we insist that you stop and make us whole through the following steps. It can be an opening to negotiation, but isn't always. Yeah, it's sort of a legal threat. And it's one of the few kinds of threats you can legally make as well. So the demand letter also made certain demands of the defendant, including the demand to that the defendant agree in writing to permanently stop manufacturing or causing to be manufactured, purchasing from suppliers, importing, advertising, marketing, offering for sale, selling, distributing, reproducing, displaying, making derivative works of, or making any other uses of the infringing products. So basically, knock it off, including without limitation, offering and selling them through the website no later than April 1st, 2024. Now, I'm just going to note here, Bad Dragon was actually surprisingly reasonable here because they're like, January 31st, they send something saying stop it, and they say stop it by April 1st. So January, February, March, April. They're giving them several months. And I know you're saying, you're a lawyer, can't you count? No. This is unusual because normally if you've got somebody who's copying your products, you just say something like stop immediately. And you might give them like 2 weeks to knock it off. This might have actually allowed SinSaint, if they felt like it, to do like a blowout sale and get rid of those products and then never sell them again. So Bad Dragon might have actually been doing SinSaint a solid here in saying, we'll let you sell out your stock. You can blowout sale your existing stock and then you're done. You know, we don't want to put you out of business, but we also don't want you stealing our business. So how does SinSaint respond? By letter dated February 16th, 2024, Defendant's Counsel responded to the demand letter. Therein, Defendant's Counsel stated, among other things, now keep in mind, of course, this is the plaintiff's view of things, the plaintiff's alleged facts. None of this has been proven yet. This is all, they're allowed to allege things, and they're allowed to a certain extent, spin them in their favor, which they might be. But they're not allowed to, like, make things up, certainly, especially about their own selves. So, I mean, I believe this time frame would be accurate. But again, I don't know for certain. Therein, Defendant's Counsel stated, among other things, the defendant had started the process of removing some of the allegedly infringing listings for product redesign. Emphasis added. This is not a thrilling response. This is not a super thrilling response. What I would have expected or hoped for if I'm Bad Dragon would have been a response along the lines of, you will stop immediately, or we will, SinSaint could have said something like, we confirm we will be in full compliance by your deadline. We apologize for any errors. We will be in full compliance by your deadline. Please don't sue us. Please. So based on the February 16th response from Defendant's Counsel, which again would have been unthrilling, and the ongoing harm to plaintiff caused by defendant's unlawful conduct, plaintiff filed suit against defendant for copyright infringement in the United States District Court in the District of Arizona on March 20th. So they didn't wait until April 1st, but they didn't wait because basically they got a letter saying, hey, we're only going to do part of this. So they're like, and the thing is saying, please indicate you will comply by April 1st doesn't actually preclude Bad Dragon from suing. It's kind of an offer. It's not, anything. The Arizona action was ultimately dismissed without prejudice on February 11th, 2025 for lack of personal jurisdiction over the defendant. Again, they couldn't sue the defendant in Arizona because the defendant's a New York company, and Bad Dragon couldn't prove that any of the dongs made it to Arizona. They wanted to get discovery to establish that some of the dongs made it to Arizona, but the court said, nah, we're not doing that. You don't have the evidence, so no. Although defendant has apparently ceased advertising, marketing, displaying, offering for sale, selling, and distributing the infringing products, plaintiff has no enforceable assurances that defendant will not resume its infringing activities. So basically they're like, we want to establish that they will never do this again. Moreover, plaintiff has incurred damages in an amount to be determined. Now, damages for copyright infringement come in multiple varieties. One variety, and this is the one usually used, is statutory damages. And what that is that the law specifies that when somebody infringes your copyright, you get a certain amount of money, and it might be a range that the court picks, or it might be a firm number. It can vary. But basically, that says this is what an infringement costs. Or you can get actual damages, which is, let's say I have a hit song and I sell copies of this hit song for, $10 each. And somebody copies my hit song and starts selling copies themselves, and they're selling them at $10 each too. They're not even undercutting me, but they sell 50,000 copies. Well, I can say, that's mine. I would have sold those 50,000 copies. Therefore, I want that 50,000 times $10, which would be a lot of money, right? All right. So, moreover, plaintiff has incurred damages in an amount to be determined. I think I just read that. Okay. So, count one, and this is where it's going to start getting repetitive. We're going to read one of these counts, and we're going to note that there are 13 counts for each variety of artificial dong. So we're going to read about Crackers the Cockatrice, and then we're going to skip the rest. So plaintiff realleges paragraphs 1 through 25 as if fully set forth herein. Crackers the Cockatrice is an original work containing copyrightable sculptural design elements for which copyright protection exists under the Copyright Act. Plaintiff exclusively owns a valid copyright registration covering the sculptural design elements embodied in the Crackers the Cockatrice product, a copy of which is attached hereto. Through defendant's conduct alleged herein, including defendant's reproduction, distribution, display, and sale of its Asmodeus product, which was copied from, derivative of, and substantially similar to Crackers the Cockatrice, without plaintiff's permission, defendant has directly infringed plaintiff's exclusive rights in Crackers the Cockatrice, in violation of Section 501 of the Copyright Act. If you're wondering, a cockatrice is a fantasy creature that was noted for turning things to stone. They're a D&D monster amongst other things. Yeah. Moving on. Okay. On information and beliefs, defendant's infringing conduct alleged herein was willful and with full knowledge of plaintiff's rights in and to Crackers the Cockatrice, and has enabled defendant illegally to obtain profit therefrom. As a direct and proximate result of defendant's infringing conduct alleged herein, plaintiff has been harmed and is entitled to actual damages in an amount to be proven at trial, as well as other remedies at law. Plaintiff is also entitled to the recovery of defendant's profits attributable to defendant's infringing conduct alleged herein, including from any and all sales of the Asmodeus product, and an accounting of and constructive trust with respect to such profits pursuant to the law. So what this means is, let's say I decide to start a business and my business is, let's say I pick a really stupid example and I decide to go after Metallica because, and Metallica is a very stupid example, like stupid choice for me to go after because we already know that they sued Napster and, they would be a bad group to go after. But I decide I'm going to start selling bootleg Metallica, whatever. So let's say I do really well at this and I make $1 million. And then eventually, of course, Metallica finds out. They sue me. They win because the case isn't all that hard at this point. Phrasing. And anyway, so one of the things they will sue for is they'll say he made $1 million on this. We want his $1 million. That should have been ours. So he's got to turn that over to us. So that's one of the things that Bad Dragon is asking of SinSaint, is saying, give us the money that you made. And that's our money. Give us. All right. So, alternatively, plaintiff is entitled to seek statutory damages of up to $150,000 for defendant's willful infringement of Crackers the Cockatrice, and for such other amount as may be proper pursuant to the law. So, if you didn't sell many of these things, we still want $150,000 because that's what this particular infringing of the dong costs. Plaintiff is also entitled to its attorney's fees and full costs pursuant to the law. So, as I mentioned, this is going to be repetitive because the next thing is the same count, but just swap in Fenrir the Wolf Dragon and Kelvin the Ice Dragon and so forth and so forth, on for 13 counts of various dong copying. So, after that, it's a fairly short case. Demand for judgment. Wherefore, plaintiff prays for the following relief. So, first, entering judgment in favor of plaintiff Bad Dragon Enterprises and against defendant SinSaint on all counts. So, the first thing they want the court to do is declare that they are the winner of the case. Okay. Pursuant to the law, restraining and permanently enjoining defendant and each of its owners, officers, directors, managers, agents, representatives, servants, employees, contractors, affiliates, entities under common control, subsidiaries, successors, assigns, and all persons in active concert or participation with any of them, including like anybody they've ever heard of, from resuming or continuing, as the case may be, their infringement of any of the copyrighted works. So they want a permanent order saying, stop it. Those are our dongs. You can't have them. We do not consent to you. Yeah. Awarding plaintiff its actual damages as suffered as a result of defendant's infringement. How much money did Bad Dragon actually lose? Awarding disgorgement, which has nothing to do with engorgement, of all of defendant's profits attributable to defendant's infringement of the copyrighted works. So any money that SinSaint made off of this, Bad Dragon is like, we want it. Put the money in the hand. Awarding plaintiff, if plaintiff so elects, statutory damages in the amount of up to $150,000 per work infringed for each applicable copyrighted work infringed. And you might be saying, wait a minute, why would they not want to elect to get the money? Well, because this is an either or kind of thing, and they want, basically they're like, we want the most money possible. And if the most money is statutory damages, we'll take the statutory damages. And if the most money is the actual damages and so forth, we'll take that instead. We want whatever pile of money is biggest. And, phrasing. Just this case is going to be impossible to talk about without awarding plaintiff its reasonable attorney's fees for each applicable copyrighted work infringed, awarding plaintiff its full costs, ordering defendant to provide a full written accounting of all of defendant's revenues and profits attributable to defendant's infringing conduct including all of defendants' revenues and profits derived from sales of the infringing products, as well as any products, works, or other materials that include, copy, are derived from, or otherwise embody any of the copyrighted works. Awarding plaintiff pre-judgment and post-judgment interest on all damages awarded to plaintiff. This is also very common. Pre-judgment interest is basically interest that accrues from the moment of the wrong, like in this case, the copyright infringement, assuming that the court finds that there is copyright infringement. So interest that accrues from that moment up until the court says, okay, Bad Dragon, you get a whole pile of money, if, again, that's what the court eventually decides. And post-judgment interest is if the court says, Bad Dragon, you get like $1 million, and it takes SinSaint a while to pay that, then SinSaint should have to pay interest on that money because they owe it. On all damages awarded to plaintiff, and that such interest be awarded at the highest legal rate from and after March 20th, 2024, the date the complaint in the Arizona action was filed, and awarding such other and further relief as this court deems just and proper. Now, that is basically court. If there's anything else you think we should have asked for that we forgot to, please give us those things. We would like those things. And this is filed by Mark S. Kaufman, attorneys for Bad Dragon. So if you're ever wondering, hey, what kind of career paths are out there if I decide to venture into law? Well, there's all sorts of options. And one of them is that you could end up being the lawyer for a company that makes sort of animal-themed dongs and suing another company that is making, allegedly, knockoff animal-themed dongs. And again, Bad Dragon is probably one of their better clients on all of this because I'm guessing they've got a whole pile of money to work with. And yeah. Now, if you're wondering, hey, how can this company exist? Everything they do is fully legal. Like they don't have any. There might be some states where like obscenity laws or something keep them from selling. I don't know. I'd have to dig into that. Maybe I'll reach out to Bad Dragon, and I suspect Bad Dragon's comments would basically be like, no, and also go away. But yeah, this is kind of a fun lawsuit because of the subject matter, but it is, in a lot of ways, serious business when they've got, a protectable thing that is worth a whole pile of money, even though that protectable thing is a design for a somewhat artistic, they used to call these marital aids, but I'm not sure how much, the marital part is strictly optional. So, yeah, they want to protect it. Assuming that the allegations are true, and again, that's an assumption, these are just allegations, Bad Dragon would have a very good claim and a very meritorious claim. If their allegations are correct, SinSaint should pay them a whole pile of money. And in fact, if the allegations are correct, SinSaint really ought to have made better life choices in terms of sending something along the lines of, we will unfuck ourselves as soon as possible, which, normally is the opposite of what you would do with a Bad Dragon product. But, so, yeah, I mean, there's folks out there who want to buy these things, and you know what? The glorious thing about capitalism sometimes is that if there's a bunch of people who want something, capitalism will connect them with it, and more than nature, the market finds a way. So, yeah, I'll keep covering this one as it comes up. I keep saying things, and then I keep regretting saying things. And, all right, let's wrap this one up before I say more things. So I hope you found this video to be interesting or educational or, yeah. Please like this, hit the subscribe button, I also want to thank my Patreon supporters. There's a link in the description below if you want to support on Patreon. But at the $50 level of Patreon supporters, Purple Dragonair, Cielo, Angela Skelton, PJs Forever, Canadian Coalition for Firearms Rights, the Canada's National Firearms Association, Canadian Shooting Sports Association, and Bottle Shock and Oz. And at the $20 level, Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, and Andrew Elsich, as well as Marvin CZ. Thank you as well to my $10 supporters who will be in the crawl immediately following. And I also owe you guys some coverage of my ongoing Supreme Court battle, I guess. So we'll cover that soon too. But for right now, I kind of needed a little break, a little refresher, something we could laugh at. And yeah, I mean, it's funny because we're talking about dongs, but it is a serious case. Like, there could be some real money changing hands over this one, and there's gonna be, I suspect, either a drag out legal battle or possibly we might see a quick settlement. Certainly, if I was, facing these kinds of allegations based on the sort of exhibit, which looks really similar, unless they have some sort of really good defense that I'm not aware of, because they haven't responded. They haven't filed a statement of defense or anything like that yet. SinSaint might be in a lot of trouble, and it might be time to contact the folks at Bad Dragon and be like, so, are you feeling merciful? Because we could really use some mercy right now. Anyway, thank you guys for watching. By the way, I was actually in Vegas around the time of the AVN Awards. I didn't go because I was at SHOT Show, which is the convention that sort of aligns more with my interests. But yeah, it's just kind of funny. So anyway, thank you for watching. Hope this has armed you with knowledge. See you next time.